Good afternoon.
Good afternoon.
The pleasure of interviewing a real Hudson County hero here, Edwin
My pleasure.
H Stern.
My pleasure. It's always really a pleasure to be here.
Judge, so you were admitted in what year?
1966.
And you went to Columbia?
I went to Columbia Law School, Rutgers undergraduate and Columbia Law School.
And what I'm most interested in is your ties to Hudson County, because we know you were 30 years on the bench, you were the chief judge of the appellate division for a number of years, you've been on more committees than I can count, but let's start with Hudson County and your recollections of starting out. Did you start in the prosecutor's office?
I graduated law school with a emphasis in trusts and estates, and I went to work after my clerkship for a lawyer who had been the student assistant for Austin Wakeman Scott at Harvard. So he had worked on Scott on trusts and the restatement. So I went to him to work with him on estate planning and trusts and estates when Newark Mayor Hugh Adonisio was indicted. And he represented Hugh Adonisio in the Newark federal investigation and indictment. And I became involved in criminal law, preparing motions and the trial. And I became very interested in criminal law and in the need for fair prosecutions. And so when Jeff Galkin became prosecutor of Hudson County, he invited me to come to be his first assistant, and I came here. And I really enjoy Hudson County. I really like the people. Hudson was quite different in those days. When I was in the prosecutor's office between 1970 and 1974, if you went down to the waterfront, you would not find anything like today. You almost couldn't give land away.
Right. There were railroad yards.
And buildings that were hardly standing. And look what it is today.
Well, it certainly is amazing. So, do you have any interesting recollections from the prosecutor's office? By the way, Adonisio went to jail.
Yes, he did. Yes, he did.
And Hudson County at the time was known for corrupt politicians.
Well, when the Hudson County trial was over, that I think was the third public corruption trial under the Lacey Stern years. Herb Stern, the then first assistant U.S. attorney, indicated he was sending to our office a truckload of documents. Unfortunately, that truck had 4 flat tires. We tried to do some investigations, and we did. I'll tell you one story involving that truckload of documents. The real key was an immunized witness by the name of Don Sherman, and he was given federal transactional immunity, and he came and testified before the grand jury on a number of matters. And I remember one case in which a public official in Jersey City was indicted. It's one of the few cases that I actually tried. 84 count indictment. We could not lose the case because the immunized witness had bought a tractor and trailer out of his own funds for the defendant, and the jury came back one Friday night and ticked off 84 not guilties. And as the jury was filing out, true story, the defendant was at the bar saying thank you, thank you, thank you to each juror, and one stopped and turned to him and in a relatively loud voice said, "You're very welcome, but next time don't do it." True story. I was in Hudson as what was first called Chief Assistant Prosecutor, because Prosecutor Galkin got somebody to teach the out-of-county and young new assistants how to be prosecutors, and that was my good friend and former judge, an excellent person, Greg Castano. And he served in the position as advisor, but was paid the first assistant salary for a year. And he taught us all how to be prosecutors. And
Greg went on to become a judge.
A judge, and was in general equity at the end of his judicial career. Terrific person. So I became first assistant at the middle of 1971 and remained first assistant until Jeff Galkin went on the bench in May of 1973, and I became acting prosecutor for a year. And I want to say, because I really do believe, that the lawyers and the bar of Hudson County was as open and as honest as any lawyers I've ever met. When they said something, they meant it. I've been elsewhere in my career, and I know lawyers who have very good and excellent practices, and they will say things like, I intend to do something, I believe something, but their intentions and their beliefs can change. When a Hudson County lawyer said something to me in the prosecutor's office, I believed it and they meant it. And so I truly enjoyed the interaction, learned something from the lawyers that were frequently in the prosecutor's office, the Jerry Millers, the Maurice Krivitz.
How about Judge Massano? Did you know him?
No, I did not know. Judge Massano is one of my closest friends now, but he wasn't in the prosecutor's office at the time I was there. He became a prosecutor later, a great prosecutor, a terrific judge. One of my successors is presiding judge for administration, the first one called chief judge of the appellate division. Just a top person, but we were never in the prosecutor's office together.
So you moved on from the prosecutor's office where?
Well, let me start by saying when I came to the prosecutor's office, we were the first full-time prosecutor's office. So in those days, all the assistants were part-time. They came in, were handed a file, and tried the case. We had no systems, we had no procedures, and I, as first assistant, started to develop manuals, procedures, processes. I remember one day I was sent up to see Judge Warner, who was the new assignment judge, about a problem, and I explained to him that there was no system for handling case processing. There's no one who seemed to have been in charge. I know what it was. We received in July of 1970, we received an appellate division opinion affirming a conviction. And I asked my secretary, a wonderful woman by the name of Dorothy Kilkenny, who called the defendant in. Well, I asked first, was he out on bail pending appeal? And she found that he was. And I said, who called him in? And she came back hours later saying, I don't know, I can't find out. The prosecutor didn't do it as a matter of routine. The warden didn't do it as a matter of routine, the court clerks didn't do it, the sheriff didn't do it, the judge didn't do it. And I found out there was no system. I also found out, unfortunately, that there were defendants out on bail pending appeal without appeals ever having been filed. They said to the judge on sentencing day, please continue the bail or set new bail, I'm going to file an appeal. And the judge said, fine. But the appeal was never filed, frequently in gambling cases. So there was really no system, and I went up to see Judge Larner. My wife knew I was going because I wore a three-piece gray flannel suit, which I had to do in those days. And I went into him, it was the first time I met Judge Larner, and I said to him, I'm very embarrassed to tell you there doesn't seem to be anybody in charge of the system. And he said, oh yes there was. And, oh my God, I'm embarrassed, here I am. First meeting with the assignment judge and I don't know anything. I said, I'm sorry, who? He said, as of now, it's you. So I literally got into what really should be court administration, as opposed to prosecutorial control of the criminal justice system. And I worked for 3 years in building a system, computerized jail lists, computerized case aging lists, to organize and make sure every case was monitored. And as a result of that, after I left the prosecutor's office, I had been asked by the Attorney General to come down to the Division of Criminal Justice as a deputy director to develop case systems throughout the state. And a funny thing happened on the way to Trenton. Governor Cahill was defeated in the primary by Congressman Charles Sandman of Watergate fame. So Attorney General Kugler did not have a job for me, and to my career benefit, he introduced me to then new Chief Justice Pierre P. Garvin. And I was to go to the AOC, the Administrative Office of the Courts, to start developing the same types of procedures through the New Jersey Supreme Court's exclusive rulemaking power and power over administration, and to develop the Hudson County system, literally, the then Hudson County system, statewide. And I went down to the, when Chief Justice Garvin died, Chief Justice...
It only lasted about a year.
49 days.
Oh,
Just
even less.
49 days.
He had been a partner with Brigadier.
I did not know that. I knew he was from Bayonne originally.
And that's where Brig was from.
Oh, okay, I didn't know that. And in case everybody in Hudson County knew Brigadier, I hate to tell Mr. Margulies that I did not take the course. So you got no derivative benefit. But Pierre Garvin had announced that he was not going to be a Vanderbilt or a Weintraub in writing opinions, that he was going to concentrate on court administration. Because with the Supreme Court of the U.S. opinions about hearings and needed findings and case volume growing, we needed to develop a system. And I was lucky enough to be asked by Chief Justice Garvin to go to work for him in Hackensack. That was the overall plan. We really never talked in any detail. And Cynthia Jacob was going to go and become director of civil practice, and I was going to be director of criminal practice, and work with him on administrative issues and rulemaking with advisory committees called the Civil Practice Committee and the Criminal Practice Committee, which still exists. And when he died, when Chief Justice Garvin died, and Chief Justice Hughes became Chief Justice, he asked me to come to the AOC but not working directly with the chief, working as part of the administrative office of the courts. And I went to Trenton and worked there. And then I left and I went to the Attorney General's office, and then I went to private practice, and then I went back to the Attorney General's office. And when I was back in the Attorney General's office in 1979, I got a call from the then new Chief Justice in August of 1979, Robert Walentz, a man of great ability and great integrity, and a man I'm very fond of and miss a great deal, asking me to come back to the AOC, and I said I couldn't come back to the AOC because I had made a 3-year commitment to be a Deputy Attorney General in charge of appellate litigation in the Division of Criminal Justice. And the Division of Criminal Justice wanted to press a speedy trial program, a criminal speedy trial program, and a decision was made to have the first judicial conference devoted to a single subject in 1980. The public defender understandably said they would not participate if it was run in the Attorney General's office, and it had to be run by the courts. So the Attorney General asked me if I would go back to the AOC, and everything worked out so well. I've been very, very lucky. I was in the AOC the second time from August, September 1979, but not officially until January 1, 1980, until I went on the bench.
What year?
I was the last Byrne appointment before the election of 1981. I technically was sworn in on December 11th, 1981, but I was assigned back to the AOC to finish the projects I was working on, and I came here to Hudson County in April of 1982.
Now, when you came back, you knew a lot of people.
I did.
You came from Hudson County. What was that experience? How were the courts different then than you understand them to be today?
Court administration was just starting in the late 70s. The administrative director, Ed McConnell, who preceded Arthur Simpson, had left Trenton, had left the AOC, and had become the first director of the National Judicial Center, National Center for State Courts. And there was a real development of court administration, and there had to be systems, there had to be administration. The volume was getting so great. For example, you could only try one criminal case a week with motions and sentences and everything else. So a criminal judge could really try only one case a week, and with vacations and holidays and the like, a good, hard-working judge couldn't try more than 35 cases. And the reality is that there was so, excuse me, there was so much volume and so little ability to try cases. Obviously, most criminal cases, over 95%, were disposed of by plea. So court administration had to be developed to make the system work. Prosecutorial administration had to be developed. And I think when I was in the prosecutor's office, as I said before, we were developing systems. The court rules through the Criminal Practice Committee have been amended. We developed in the prosecutor's office, I'm proud to say, procedures that allowed no-bill remands, which was something that was questionable when we went in. We ended up with an Attorney General's opinion letter letting us to do it. In other words, taking an indictable that was sent to the prosecutor's office for presentation to the grand jury. We developed systems to administratively close the file or to administratively downgrade a case before grand jury presentation to a non-indictable and send it back to the municipal courts. All of this was ultimately step by step as we were doing it, approved by directive or AG opinion letter, and ultimately by rules. And we developed a system so that only the cases that had to be tried were really tried. The volume was reduced so you could concentrate on the cases with multiple career criminals or significant crimes or public interest matters. And I guess the best answer to your question is with trial court administrators and division managers created, it became a more systematic procedure.
And how long were you on the trial bench?
They didn't let me try cases. I was here in Hudson only from April of 1982 to the fall of that year, because I was assigned to my home county of Essex, starting the next judicial term in September of '82. And I went to the Judicial College to learn how to be a judge over the period of time I was here in Hudson. So I wasn't here more than about 4 months on the bench. I went to Essex. I was there for 3 years, from September of '82 through August of '85. And in those days, we had a new capital procedure adopted, as I recall it, in August or September of '82.
Capital, you mean death penalty?
Death penalty. And I was one of the 2 judges assigned to try capital cases. So most of my time in Essex, in the 3 years that I was there, was trying capital cases.
Now, I understand you've written about 450 published opinions?
452, but who's counting? Well, I'm going to keep writing until I get one right.
That's what practice is all about.
That's right, exactly.
One of these days you'll get good at it.
I'm not sure, but I'll try.
You'll try. Any interesting issues that you think are significant that you decided?
Absolutely. Absolutely. I think each one is. Every case is different. There is something in the factual complex, even where the law is settled, that makes every case different, and that's why I enjoy the law so much. I can't single out anyone that is more significant than the other. I will tell you the 2 cases from my judicial career that stand out the most. One.
Now, these in the appellate division or the Supreme Court?
No,
Because I know you sat on the Supreme Court.
Yes, but in the appellate division.
Okay.
Well, no, one in the Supreme Court, I'm sorry. One of the 2 most significant cases was a case called Abbott versus Burke.
Sure.
And I was the swing vote in one of the cases, and that obviously is very important. But the case that I remember as probably my most important case is not a published opinion. It has no precedential value. It probably isn't even a well-written opinion. But in my first year on the court, early on, we had a motion in a child termination case. And to me, the child termination cases were among the very most important things judges do.
And that's where you terminate the parental rights of a parent with their child.
Absolutely. And I remember my new judge sitting on the appellate division with one of those able, decent people I ever met, Herman Michaels, who was then the presiding judge of the appellate division and the presiding judge of my part, and my mentor on the appellate division. And I read a motion to permit supplement of the record. And I called him and I said, oh, the mother whose rights were terminated must be making wonderful progress. I grant the motion. And he told me, no, we don't grant such motions because we decide appeals on the record made. We went to argument, and in those days we had what we call CRIS lawyers, lawyers assigned to represent parents in termination cases before the public defender did it. And the lawyer said at the end of his argument, my client would like to say something, and this woman stood up, and Judge Michael said, no, she has a lawyer, you will speak on her behalf. And she sat down, she looked well manicured, and after the arguments, we went into conference, we got to that case, and I, for the first time, was going to speak what I thought independent of whatever my mentor said. And I said, something has happened in this case. Something has happened to this mother. She really must have gone through rehabilitation or counseling, and I would like to see her have an opportunity for reunification with her child. And to his credit, Judge Michael said, oh, if you can send it back, I'll join you. And I was really pleased to hear that. And I wrote a very technical opinion. I don't remember what it said, but I remember it was technical in a way to get it sent back to the family part. And about 4 months later, we got a letter that the Division of Youth and Family Services, as it was then named, was dismissing the termination complaint and had provided for reunification. And to me, that was probably the most significant opinion I ever wrote. I can't remember the name of the case, but the idea of a mother and her child being reunited, to me, is as important as anything else.
Well, I think that says a lot about when they talk about judicial philosophy, when they talk about the rule of law and what it means. It doesn't mean the guardrails are can't be moved, can't be flexible. That you really are, sounds like you really were concerned about seeking substantial justice.
Well, as I said before, each case is different, and a lot of cases are considered routine for purposes of precedent. They are, but as I also said, there's at least a wrinkle different. Let me tell you, if I might, talking about a Hudson County story, one of my favorite Hudson County stories from the prosecutor's office. It's hard to tell. When I was first assistant, a young man from a school in this area was found lying in a gutter behind a schoolhouse. And he apparently had been hit over the head with a wooden bar. And the person who did it ran into the parochial school where the two attended and ran up to his teacher and said, we just had a fight and so-and-so is lying in the gutter. So the teacher, Sister Margaret Murtha, picked up the phone, called the police department, said so-and-so is in the street, in the alley, and the victim ultimately died. So the grand jury was conducting an investigation. And obviously, knowing Sister Margaret Murtha had made the call, identified herself. She was called before the grand jury and claimed a priest-penitent privilege. And unfortunately, because she had identified herself properly and nicely and had advised of the statement that she had been told by the perpetrator, the grand jury wanted her testimony, and she refused to testify. So, who do you think was sent up before Judge Sam Larner to argue for the civil contempt or incarceration of a nun in Hudson County?
You got it.
Yours truly. It was a hard thing to do. And Judge Larner ordered, I think properly under Rule 110, her incarceration until she would testify. And actually a friend of mine, somebody at my wedding, who was then apparently counsel to the archdiocese, went to the appellate division to get a stay, to which we consented. And there is a published opinion in 115 NJ Super called In Re Margaret Murtha. I hope I'm right with the name and the citation. But there was Ed Stern with a Hebrew background urging the incarceration of a nun in Hudson County. I was not too comfortable, and I prayed that we could work it out, pressed for a stay, and the bottom line was that it was worked out. The perpetrator entered a plea, but Sister Margaret sent me Christmas cards and letters for some period of time.
Yeah, isn't that something?
Yes, I mean, typical Hudson County good people story.
So, how was the Supreme Court? How was that experience? How long were you on the Supreme Court?
I was only on it for 9 months. I was temporarily assigned when Governor Christie did not reappoint John Wallace. I was senior judge, so that under the rule, I was temporarily assigned. Unfortunately,
Who was the chief then?
the chief was Radner.
Okay.
Radner had come in 2007, and this was September of 2010. So I spent my last year on the bench on the appellate division. And to be honest, believe it or not,
We expect that, by the way.
well, I try to be. I have to persuade myself that I'm right. I liked the appellate division perhaps more than the Supreme Court for two reasons. One of the reasons was that one of the justices did not think I belonged on the Supreme Court because he read the Constitution to say that a temporary assignment could be made only in the absence of a quorum. Whereas there had been a long and rich tradition of having temporary assignees for any number of reasons, including having a full court, because I had been temporarily assigned to several cases over the career.
It's always an odd number, so
Well, unfortunately,
it's not always, but
Yeah.
less likely you're going to end
Yeah,
up with a
Absolutely.
stalemate.
In fact, the Law Journal wrote an editorial 2 years or so ago urging that there always be 7, certainly so that there not be 6. Because to me, it's not appropriate to affirm by an equally divided court when you can have an odd number. You need 5 for a quorum, but the editorial advocated 7. And certainly always a 7th if the court seemed to be divided, if one and only one was recused or disqualified. You would never know if 6 were sitting, whether it would be 5-1, 3-3. So I've always advocated for a 7-member court. So I felt a little uncomfortable because during the conferences and on the bench, with the feeling of one who felt I shouldn't be there, and one who felt, and this is all in a published opinion called Henry versus the Department of Human Services. One thought I wasn't needed, one thought I shouldn't be there. So I was somewhat uncomfortable. As important as the work is, and as honored as I was. But also, I liked the appellate division for 2 reasons. One, the volume was so great. Some years we were writing 5 opinions a week, sometimes we were having 2 arguments a week, and on the more routine weeks we were doing 4 opinions a week. So that...
and that's how many judges? 4?
4 judge parts. 4 judge parts sitting in panels of 2 or 3. And Bob, to be perfectly blunt, there was something I liked about knowing that somebody could review me and tell me if I was wrong or made a big mistake. That couldn't happen in the Supreme Court, except in a federal constitutional issue case that was the subject of a petition for certification, for certiorari, or a criminal case that would go through a habeas proceeding and then on appeal. There was something I didn't like about being last and not thinking of something or seeing something. And as much as I enjoyed the Supreme Court and learning from people like Stuart Rabner and Virginia Long and Janie LaVecchia and Barry Albin, who were all there when I was there, the appellate division was very different.
Well, when you were on the appellate division for many years, not only did you sit regarding the cases and write opinions, but you also were in charge of administration. I mean, that's quite a load, isn't it?
For the last 7 years, I was presiding judge for administration. And going back to my Hudson County days, I loved administration. And that's why we developed so many different systems with the help of a great clerk, Joe Orlando. We developed a good number of procedures. But but again, I like the feeling that if I was wrong and missed something, I could be corrected. That was one of the beauties.
How often did you find the need to dissent in the appellate division?
I dissented a fair amount. I'm smiling because I'm about to tell you what I mean. I called many of what many people would think were dissents, concurring opinions, because I did not want to force cases on the Supreme Court. As you well know, there's a right of appeal to the Supreme Court from a dissent in the appellate division. The more dissents there were, the less the court would have an opportunity to certify cases that they thought they should be deciding. So my concurring opinions often said, I think this issue should be looked at, and I'm going to join the majority because they are right under existing law, or I'm duty bound to follow precedent, but here is my concern. I know the court appreciated it because they didn't like cases forced upon them. They have a limited caseload that they can take and handle, and as every case has to be written as precedent. So I know I don't think I wrote more than 12 or 14 actual dissents. I do have the figure somewhere. In the 27 years I was on the appellate division. And those were cases that I think involved new law, important public interest issues that warranted dissents. One of the beauties of the New Jersey system, and it's known nationally as one of the best, if not the best, judicial system. The Chief Justice, well, the court has unique powers over practice and procedure and administration of the courts, which through committee recommendations and independently, the court makes rules to keep the judicial system modern. And the Chief Justice, though, has separate, independent, and exclusive powers, separate from the court. And one of them is the power to assign judges from the trial court to the appellate division. There are only 2 states, one New York by the governor and one New Jersey by the Chief Justice, where the appellate judges are taken from the trial court. In this way, the Chief Justice's assignment power allows him or her to put each judge where the chief believes that judge is best suited to sit, based on his experience or her experience and background and the like. And so one of the good things about the appellate division is that everybody gets along or they are moved, so there is not internal fighting. That doesn't mean they don't disagree, that doesn't mean they shouldn't disagree. But if there are any personality differences...
You mean judges are people too?
Judges are entitled to the same rights as others. I was an active member of something called the Council of Chief Judges of State Courts of Appeal, and I remember going to conferences in states where the intermediate appellate judges were elected, and some ran on a platform to get rid of their colleagues. Some ran on a platform to change the law that the colleagues wrote. One came in and said, I want a whole new computer system. makes New Jersey a much better system?
So a few years ago, I had the opportunity to lecture to some Polish judges. And it was before the government changed, it was a right-wing government. And when I went, they said, you know, see the two ladies over there, there were 46 of them, they're spies. I said, what do you mean? They're sent by the Minister of Justice to see what's happening at this meeting. And they were interested in two phrases: judicial independence and rule of law. So what I want to ask you is a very tough question. We're now in 2025. You've had almost 60 years of experience.
Don't rub it in.
Well, I think it's important. And
No,
I am rubbing it in because I think
I'm talking
experience.
about my age.
No, but I think experience is important.
Yes.
I'm not that far behind you. Talk about where we are in terms of rule of law and judicial independence today, both in New Jersey and in the country.
Well, I think New Jersey is very different than the country now. I think we have an excellent Supreme Court with an excellent composition of judges. New Jersey has always honored the 4-3 or 3-3-1 political composition. By that I mean we've never had 5 justices from one party. I've sat on the Supreme Court for a year, but in a number of cases to create a quorum or otherwise temporarily assigned, I've never heard any discussion about political background or party affiliation as affecting cases. I can't say enough about our Supreme Court or the regard in which it is held. It has developed the law of